novo standard review, cited the Mulford versus Walnut Hill Farm case.
Tell me if I look awful at. Make sure you comment, like, share, subscribe.
Was had they filed a proper notice of appeal.
If I look tired, it's because I am tired.
The Court of Appeals needed to apply the principles.
Margie, bring them on camera. It's only audio.
Cited in the brief. In making a determination of
though we should see the
whether an
look on their
appellate
face.
court acquires jurisdiction over a case.
Can you send it to
In order to confer active jurisdiction on the appellate court, a notice of appeal must be timely. The notice of
How do I do
appeal
that?
is timely.
Oh, share.
And it must adequately identify the case to be appealed. We clearly did that. The notices were provided to all the persons in this case. Who were represented by Mr. Eads, the defendants, the persons who participated in the hearing this party, all received notices. And clearly, the appeal had adequately identified the case to be appealed.
Because I'm not.
The only reason that
Can I
the
at
pro
you?
se notice of appeal cited the names of signers was the style of the case. That was the style of the case that was signed way back in 2018. And then when the judge enters his order in January of 23, even though he's ruled the signers are no longer parties to the case, he uses the style of the case that was written. The fact that they used the wrong style of the case doesn't suddenly make non-parties parties to the suit. It's simply an incorrect style of the case, but it does nothing to deprive the Court of Appeals of jurisdiction to hear the appeal. And so this was plainly a wrong decision by the Court of Appeals that failed to apply the standards that are set forth in the Gamma-Shuley case and the Roberson case and the Nicholson case. They were just flatly wrong in ruling that this case needed to be dismissed. This is a case that had merits, and they simply failed to address the merits on a plainly incorrect application of saying we don't have jurisdiction. We've got this person who's incorrectly named in the style of the case. We're deeming them parties to the case when in fact they never were. It's specifically plainly clear from the record. Just note the kind of things if the Sawyers actually.
What would they put that on the same thing?
Well, why is it that they were excluded from the courtroom during the hearing? If they were truly parties to the case, why was it that they were not allowed to cross-examine witnesses or call witnesses or participate in the trial? As a
just woke up.
I'm sorry?
It does not appear that they had any interest in participating.
They were explicitly excluded from the courtroom by the trial judge, Judge Patton. They were not allowed to participate. They were not given notice of the proceeding. They were not asked to endorse the final order Judge Patton rules on. And it's obvious why he didn't do it. They weren't parties to the proceeding.
Look at
and
you.
So it's truly spurious reasoning to suggest suddenly on appeal because the pro se notice of appeal employs the style of the case originally signed way back in 2018. Suddenly they are parties to the case. That's plainly wrong. And this case needs to be heard on
hi.
The Court of Appeals decision needs to be reversed and tell them to address the merits of the appeal.
There was somebody watching, then they went away.
An easements case, and it's simply incorrect.
Free Lulu.
There's no justifiable reason on the case law that applies for determining whether a Court of Appeals requires jurisdiction. There's no basis
her picture looks different there, but her picture looks different on
there's an
Messenger.
indispensable party who was never a party to the trial. And it's plainly wrong.
He said,
I think
like, you're frustrated with all
arguments
this shit.
after the brief, defer to allow the
Because his voice will raise and then it'll go lower, like, sorry for yelling.
Next case before us is Howard versus Radford
Y'all.
City Department of Social. Good morning, Mr. Kohler.
Morning, Your Honors. May it please the court, I'm John Kohler, the Salem Monroe County Bar.
I need
I have
to.
the
I
privilege
don't
of
know where my
representing
cigarettes
Ms.
are.
Keely Howard, who appeals a decision of the Court of Appeals affirming a judgment of the Radford Circuit Court
A cigarette.
sustaining
Not
a
a lighter.
petition to terminate her parental rights. I'd like to address the procedural issues that I think are the real bar to
Tell her.
reviewing
tell
the
her.
merits of this case. This court has said many times that the title of the statute is not part of the statute. It's the substance of the words of the statute that matter. This court has said many times that the title of the pleading does not matter. It's the substance of the pleading that matters. And I had thought that the law in the Commonwealth was that you don't have to use a magic word in an objection so long as the substance of the objection conveys the issue that you're asking the court to decide. The Court of Appeals here
That's the
focused
other
on
way,
a single word made by trial counsel in objecting to the testimony of Nurse Butler, which was, or I should say two words, best evidence, and determined that that was not, in fact, the appropriate objection. The objection should have been to her being allowed to testify to hearsay of what was in this document that trial counsel said was the best evidence to establish the nature of the diagnosis of the child in this case. And we would simply submit that having not said the word hearsay, but in every other respect making clear that the objection was that, and this of course is presuming that Nurse Butler was qualified as an expert, which is a different issue, that she should be permitted to testify to a medical record which stated a diagnosis which was found in a different, which was never presented to the trial court, and to give her opinion on that diagnosis without laying a proper foundation for that diagnosis having been brought into evidence. And our position is simply that the best evidence rule is a corollary to the hearsay rule. Best evidence means when you have a document that proves a fact, you do not prove that fact by someone referring to the contents of that document, i.e.
Imagine
hearsay.
if you're opposing counsel and counsel stands up and makes the best evidence objection. You know, it wouldn't be right for you to stand up and say, really what she means is hearsay and she's mixing this up, but let me help her make the argument against my client.
I'm not suggesting that opposing counsel should correct the verbiage.
What about the trial
objection.
judge? If the trial judge has said, you should know the difference between their corollary doctrines, but there's dozens of courts. You got to tell me which one we're talking about. You have a lot of hearsay exceptions have nothing to do with best evidence, vice versa. At some point, the reason for this, what you see, I think see as too much specificity is that it protects the adversarial system so that everyone really represents who they're supposed to be representing.
And with respect, Justice Kelsey, I don't think that that is my argument. My argument is that the substance of what counsel said, just if he had never said the words best evidence, the substance of his argument as to why Buckner should not be allowed to testify to the contents of a document that was not in evidence was that her testimony was speaking to an out-of-court declaration
So they're
made by a
saying that
lab technician in a
piece
written
of paper that
document.
she had in
And if the
court.
words best evidence were not
Will you
anywhere in
print
the
that
record,
one
and the word hearsay was not anywhere in the record,
The
I don't
piece of paper
believe
that she had in
that the court
court
would say,
wasn't
I didn't
hers.
realize the nature of his objection. His objection was very clear. There is
And
a
it wasn't
document that
presented before
establishes
as
this
evidence, so they're
diagnosis.
trying to
Work
get it
in
to
reverse
not be
from her perspective. Someone made a
inadmissible.
technically a best evidence objection, not a hearsay objection, fundamentally or conceptually. But call it a hearsay objection. Would the trial judge say, you keep calling it a hearsay objection, but let me correct you, it's really best evidence, and here's how that works.
It would depend on what the nature of the words supporting the objection were. If someone stood up and said, Your Honor, that's hearsay because they're not calling the lab technician who is the out-of-court declarant of what is in that document. I would agree with you. That is clearly objection, not a best evidence objection. But if the objection were, Your Honor, that's hearsay because there is a document that proves the content of what this person has no personal knowledge of, that is a best evidence objection. What I'm saying is that if I say to a court, Your Honor, I object on relevance, and then I make an argument that the evidence, while relevant, is more probative than prejudicial, I don't think a trial court can say, counsel, you started your objection with the word relevance, therefore I ignore everything in your argument.
Well, that one's the easy one because legal and logical relevance is under the umbrella of relevance.
My point is that starting an objection with a particular phrase does not require
Don't
the
screw
court
it up,
to
Louis,
then
lawyer
assume
boy.
that the substance of the objection that follows is governed entirely by that phrase.
Oh,
If I
I
could
think
move on
he should
to
have
what I
talked
think
to
is a
you
more central issue in this case,
personally
which,
to ask
and
you
first of
what
all, I would
happened.
disagree with the Court of Appeals that the argument regarding whether or not there was proof of abuse or neglect, convincing evidence, was dependent upon whether or not Nurse Buckner was to be admitted as an expert testimony. I believe that even if her testimony was proper, even if her reference to the diagnosis was proper, the question still remains whether or not at this stage of the proceedings, there was clear and convincing evidence of abuse and neglect of this child, warranting removal for the failure to satisfy the conditions of the department. And let me simply be very clear on this. The process in DSS cases is you have a removal in which you have an initial hearing, as the court knows. That is not appealable. You then have a 30-day hearing, which is appealable to the circuit court, and then further appealable to the Court of Appeals and this court. I almost said this court, but since for 2 years it's changed. I see my time is running out. I'll try and be quick. The standard for the removal at that point is preponderance of the evidence. It is our position, and I thought it was the law of this Commonwealth, quite frankly, until Judge Lorish asked me if it was, and I was baffled. I said, yes, I'm almost certain it is, that the removal is simply the preliminary stage, and the department must still prove abuse or neglect by clear and convincing evidence, even if the parent has not complied with the department's request. In other words, subsection B and subsection C2 of the statute both require clear and convincing evidence that the initial removal and the subsequent decision to terminate parental rights
My
was
connection
based
is
upon
slow,
an
sorry.
abuse or neglect of the child. The evidence here simply does not establish that. What we know is the child was diagnosed with human papillomavirus. We know from the evidence that that virus can lay dormant in the body for many years before outward signs. We know that as soon as there were outward signs, the mother took the child to the doctor and sought treatment. And we know that this child was at one point in the custody, or at least the care, of her father, a convicted child sex abuser. The department presented no evidence that at any point, in fact, conceded that the mother was not the source of the disease, that at no point could they establish that the child was left in the care of someone who might have transmitted the disease to this child. That simply cannot rise to the level of clear and convincing evidence. And while I will concede that Ms. Howard was very combative with the department and not willing to accept this assertion that she had endangered her child by somehow allowing the child to be exposed to sexually transmitted disease, it still can't be clear and convincing evidence that Ms. Howard was neglectful of the child. There is no evidence that the basis for the removal, the fact that the child had a sexually transmittable disease, was the result of any act or omission by Ms. Howard. And I would remain, I would rely on the remainder of my issues as they're stated in the appeal. Thank you very much.
Thank you very much, Mr. Coleman. The next matter is Webb versus Commonwealth. Mr. Santan.
May it please the court, I'm Joseph Sanzone and I represent Mr. Webb.
This is why that lawyer
Thank you,
should have
ma'am.
talked to you.
Sometimes
You need to call that lawyer, and you need to call that lawyer now. What the fuck? No. Absolutely motherfucking no.
I mean, he never emailed me or anything.
No. And if the secretary
She says she listened, but she does. So she doesn't know when she wants to know when the outcome.
Well, if his secretary says he's not there, you tell her to tell him to call you immediately. What the F? Just freaking
I
what?
couldn't hear the options.
Thank you for calling Buckland Law Firm. For Jason Buckland, press 101. For Zach Smith, press 102. For Beth. To connect you.
And you put some emphasis on it. Don't, yeah, no, absolutely not. Absolutely no fucking way. Nope. This is why that lawyer should have called you, talked to you, set up something.
Hi Zach, this is Keely. If you can call me back as soon as possible, please. I don't know what just happened. I watched it, but if you can call me back, that'd be great. Thank you.
Wow.